Welcome to Part 7 of our video series on detailed reading of the Digital Personal Data Protection Rules, 2025. Please check the Part 1 to get an overview of all the rules and the grouping of the rules. In this video, we will review the rules that are grouped under Significant Data Fiduciaries and Individual Rights rules. As discussed in Part 1, the DPDP rules comprise 23 rules, and we have grouped them into 8 groups for easy reference and understanding. Again, as discussed in Part 1, these rules are supported by 9 high-level schedules, and we have grouped them into 4 groups. This video focuses on Rule 13, regarding the additional obligations of significant data fiduciaries, and Rule 14, which outlines the rights of data principals. Rule 13, Sub-Rule 1, states that an SDF must undertake a data protection impact assessment and an audit every 12 months to ensure effective compliance with the Act. Sub-Rule 2 requires the SDF to furnish the board with a report containing significant observations from this assessment and audit. Rule 13, Sub-Rule 3, requires an SDF to observe due diligence. Technical measures adopted should not likely pose a risk to the rights of data principals. Sub-Rule 4 mandates that SDFs undertake measures to ensure personal data is not transferred outside the territory of India, based on recommendations from a central government-constituted committee. Continuing with Rule 13, Sub-Rule 5 clarifies that the term committee means a committee constituted by the central government for the purpose of this rule. This committee will include officials from the Ministry of Electronics and Technology and may include others from different central government departments. Rule 14 addresses the rights of data principals. Sub-Rule 1 mandates that data fiduciaries and consent managers must prominently publish the means for data principals to exercise their rights and any required identifiers on their website or app. Sub-Rule 2 says that the data principal can make requests to exercise the rights through the means published by the data fiduciary. Rule 14, Sub-Rule 3, requires data fiduciaries and consent managers to publish grievance redressal system information on their platform, responding within a reasonable period, not exceeding 90 days. They must implement appropriate technical and organizational measures for effectiveness. Sub-Rule 4 allows a data principal to nominate individuals to exercise their rights under the Act. Continuing with Rule 14, Sub-Rule 5 defines identifier as any sequence of characters issued by the data fiduciary to identify the data principal. This includes things like customer ID, application numbers, enrollment IDs, email, mobile number, or license numbers that enable identification. We recommend the Calpi Quiz app, available on the Google Play Store, to test your knowledge of cybersecurity, the DPDP Act, and other important topics. The app offers various levels of difficulty and interactive assessments to improve your awareness. Thank you for watching this video relating to the raw reading of the DPDP Rules 2025. Hope you now know more about the rules given in the document. This was the 22nd video in this series, released by DPDPA-mentor.in. Please visit our YouTube channel, DPDPA Mentor, as well as our website, DPDPA-mentor.in, regularly to check out other informative resources. Wishing you a successful DPDP Act implementation.